Hi folks, it's Alex Woods. This is a YouTube channel dedicated to helping you navigate your way through the court system of England and Wales, as well as demystifying the court system. And it's based on actual live cases. All whilst I've been running litigation, I find a way to blog about. So the knowledge that you're getting is real life law in action. Now this is a vlog that I've been wanting to do for some time. It's a bit of a bee in my bonnet. I don't like the way lawyers don't seem to be at all invested in their clients' cases. They're not like regular businesses where you offer a service or a product in return for some money and you deliver that product or service. You know, even going into the opticians and getting your eyes tested and getting a pair of glasses, you know, if you can't see a bloody thing and you come back to the shop, you expect your money back. With lawyers, they'll ask you to put a large amount of money on account, and then if you can't, with lawyers, they'll expect you to put a large amount of money on account, okay, and then they'll give you some advice, and you have no idea whether that advice is good, bad, or indifferent. And that advice could be, we don't think there's much merit in your case. We're not sure. Caveat, 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 caveat. We haven't seen all the available documentation. We don't know what your opponent is going to do. We haven't seen evidence from them. We've taken instructions from you, but we kind of don't trust what you have to say. There may be other witnesses that are more important. Here's our advice, some vague yes, no, or in the middle. Here's our advice. We don't even quite know what amount of money you're likely to win if you were to win. And basically here is our invoice. You think, that's an interesting transaction. And I've been asked to put a large amount of money up front as well. Now, if you think this is just me sort of soapboxing and crusading against lawyers, the reason, as I say, I do these vlogs because usually these are issues that I've actually come across. And I come across this quite a lot. And I come across this in a recent case where the client had parted with an eye-watering amount of money for a respectable blue-chip London law firm to help him with his case. And what I've described is exactly what happened. There was no real result achieved. I mean, even a result which said, look, this is complex, this is high value, we're an expensive law firm, we don't do no-win, no-fee litigation, we just think that it's going to cost you 50,000 plus, get on with your life, you know, and given him that tough love, even that would have been quite strong advice. But no, even that would have been rather quite a good service. But no, they hadn't even done that. And the advice that they had given was compromised because it was sort of general, hadn't drilled into the detail, and their excuses because they won't have seen all the documentation. And it was just sort of a general cautionary advice that his case was perhaps not as strong as he thought it was. I mean, they didn't even. This is why I get phone calls from consumers who ring up and say, "Can you write a letter, please? Here's the text. I just want it on lawyer's letterhead." Because this particular law firm they didn't write a letter, but they didn't actually issue proceedings. They just simply didn't put any of their money where their mouth was, and they, as I say, they separated a large amount of money from my client in the process. So it seems to me that there are dangers and pitfalls and problems with instructing lawyers. You need to be pretty careful about who you instruct. Now, in the defence of lawyers, should they need defending, or perhaps to explain to you the way the world works, is that a law firm, just like any other business, is got certain drivers, and their drivers are to invoice a certain amount each month, for litigators to bill a certain amount each month, and they're under the commercial pressures of everybody else. And they're kind of more deregulated and likely to be even more deregulated than they were traditionally, so potentially more motivated to cut corners and make compromises. But in defence of them, they are being paid to give you advice. The problem is you don't really know what the quality of that advice is, and the lawyer's got no investment in the outcome. Most businesses, if the car doesn't work, it's going to be bad, it breaks down, it's going to be bad for the business. It's quite, and it's also quite clear when it works and when it doesn't work. Just general advice often isn't particularly clear. So this is a vlog about the sort of things that you should have half an eye open when it comes to choosing and to instructing solicitors. Well, I'm talking specifically about litigators, and particularly about general litigation and the areas, the specialisms that I operate in, that Redwood Legal operates in. I think the first thing to say is, just because they've got a blue chip reputation doesn't necessarily mean you're going to get an individual fee earner who's going to, fight hard for your particular case. And you know what? Unlike, say, in the building sector, where reputation is critical, if you go and instruct a small builders around the corner and they've only been in business 18 months, well, take your chances, frankly, because they'll probably set up a limited company. If it doesn't work out, they'll fold and they'll set up another building company in a couple of years, couple of days' time, and no one will be any the wiser. Yeah. But where law firms are concerned, it's quite difficult to become a law firm. It's quite difficult to qualify as a solicitor, let alone get qualification as a lawyer, even an individual sole practitioner. And we have a hefty overhead of professional indemnity insurance. We are insured. We have to be insured. And insurance is very expensive, and we don't like complaints because they put our insurance premiums up. And if we get in trouble with clients, if we're at the wrong end of a professional negligence claim, we may even get struck off or get a penalty against us. That is not looking good for our future career. So on the whole, what's the word? If you're comparing apples with apples, as it were, I know we're comparing slightly apples and pears, but on a level playing field, reputation isn't so critical. And I think also reputation isn't so critical because the person who's built that reputation probably isn't the individual who's actually running your case on a day-to-day basis. You need to check out that person and find out who that person is. Now, the lawyer might not, the lawyer with a high reputation might not be running that case, but he might be supervising it. Well, that's fine. But be careful if a blue chip name. No, I'm a small law firm, so I would say this, wouldn't I? But be careful of a blue chip name. So that is the first thing to be said. Be looking for a conscientious lawyer. There are the Legal 500. There are books that you can. There are league tables of individual lawyers. I often, when I'm looking for barristers, I'm a solicitor and I'm interested in instructing a barrister, I will often go to landmark cases that barrister has been involved in and read the whole case. Don't set much store by testimonials. Anybody can get anybody to write something nice about them and stick it up on a website. Above all, of course, it's helpful to get on the phone to them. And perhaps this is the second thing. When you are on the phone to them, check that they can check that they're actually flexible where it comes to retainers. The retainer is a contract between you and the lawyer. Check that they can do, for example, a no-win, no-fee agreement. That's really important in litigation. The large amounts of money are in danger of being expended in running litigation that can actually dwarf the litigation itself. Is that lawyer prepared to invest in your case and become a partner? Now, that is now not all cases should be done on a no-win, no-fee basis. I've done another vlog on this issue. But the taximeter, the old-fashioned taximeter approach, may be right for a claim that's a large amount of money, and you don't want to part with 25% of a very large amount of money for a case you think is very strong, and an opponent you might feel is going to capitulate after one or two letters. But what I'm saying to you is, find a lawyer who's prepared to have that conversation and who's open-minded and flexible enough to look at a no-win, no fee. Even if they won't look at a no-win, no fee, maybe they'll look at a reduced no-win, no fee. They'll take a smaller percentage of your winnings and cut their hourly rate in half. Why that is really helpful and important in litigation is it means that you can be reassured that the lawyer has an investment in the outcome of your case, is motivated to do the job well. He's not just going to be paid just for giving you advice on a taximeter basis. So I think the second thing to bear in mind is that the individual lawyer that you found is prepared to talk about being flexible in respect of retainers. The legal landscape now allows no-win, no fee in all sorts of different blends. Not just the personal injury sector, lots of sectors now use no-win, no fee. Okay, the third and final sort of point in relation to checking out your lawyer is really, it's common sense, isn't it, to try them out. So the client of the case to which I've referred at the beginning of this vlog, he gave me a small bit of litigation to run that was semi-related to the bigger case that he then instructed me on, and I didn't know it at the time, but he was checking me out, and we got a reasonably good outcome in that, and so then he instructed me in the larger case. Now that is common sense. Don't be intimidated by the lawyer. Try and ring fence things at the beginning and say to him, look, I'd like a little bit of advice on this problem and this dispute, whether to go forward or not, what likely range of winnings I would get if I was successful. Have I got a 10% chance, an 80% chance of success? Just as you would say you're setting up a business and you get an accountant or a consultant or some business guru to look at your business and your business plan. So, because litigation is a commercial and entrepreneurial endeavour, get an expert in to look at your case. So that's a good way, and whatever it might be, £250 for a small claim, £1,000 for a medium claim, £5,000 for a much bigger claim. He's going to do a review, and the important thing is you're going to be able to find out about him, and he's also going to be able to find out about you. Because he'll want to know whether, if he's going to do a no-win, no fee, for example, whether he's backing a winner or a loser. Right, so those are the three things. If you're wondering about and you're a little bit confused about the whole area, you've got to do a little bit of work, and you've got a proper bit of prospective litigation or dispute that you need some legal assistance with. Because as often as not, you can negotiate your way all the way to the moon, you can be nice and compromise all your way to the moon, but as often as not, a lot of people are not going to take you seriously until they get a letter from a lawyer, or these days actually until they get a claim form from the courts, until you've actually issued proceedings against them, I'm afraid. So I just want to conclude by saying that be careful of no-win, no fee. The personal injury sector has used and abused no-win, no fee to a point. Not everyone, of course. They are a big factory. They take on lots of cases in order to mitigate their risk. They're often driven by an approach to complete the case as quickly as possible, and they don't really care how much you get. That's kind of often in the personal injury sector, often that's an absolute kind of free lunch. And you may think it's all going very well, but it's actually all being stitched up backstage by your lawyer and your opponent's lawyer and the insurance companies. And you may not be getting, if you do get a result, as often as not you will, you may be getting a small amount of money and being encouraged to accept it early days. So be careful. No win, no fee is definitely not appropriate for all cases. Perhaps not for many. Perhaps I don't know. Perhaps not right even for the majority of cases. But anyway, you can kind of find a good lawyer and you can get them to do a preliminary bit of work. No such thing as a free lunch. If you want to know more about no win, no fee, I've done a separate vlog on that. Okay, so I hope that has been of value. Just have a quick look at my notes to make sure I've covered everything that I need to cover. Yeah, don't be seduced by high-end blue chip firms. Find out, ferret out individual conscientious litigators. Yeah, litigators, not just an average general lawyer. Number two, make sure they're flexible about retainers. Number three, try them out, test the waters, get them to do preliminary advice. Make sure you're not, in for a penny, in for a pound until you're sure that that lawyer is the right lawyer for you. Okay, thank you for tuning in. If you want advice and assistance, tune off if you've heard this before, but I'd like to just bolt this on at the end of my videos. Go onto the Small Claims Track website. I give some guidance on how to approach us for advice. But essentially, write in an email the story of your case, 2, 3, 4 paragraphs or 1 page or A4. Attach all relevant documentation as a PDF and put them in preferably reverse chronological order, but at least chronological order. Put all the documents into chronological order. We will then look at those and quote you a price for reviewing your case, okay? And that will save you money because lawyers often end up billing clients, for doing what is really little more than an admin task. Okay, hope that's been of help. Look forward to vlogging to you in the very near future. Bye for now.